Today we're going to talk about the difference between formal and informal probate. My name's Gregory Singleton. I'm an estate planning and probate attorney living in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. Also, two housekeeping things. None of what you hear today is legal advice. This is just an educational video. I am not creating an attorney-client relationship with anyone that watches this video. Also, we're going to be talking primarily about Minnesota law. If you live in another jurisdiction, a lot of the theories and things that we'll talk about will probably transfer over, but make sure to talk with an attorney in your state or scour the statute yourself if you have a specific question. Okay, so general differences between formal and informal probate. Now, we're actually not going to talk about and harp on the procedural differences, and there certainly are some. What we're going to focus on is the reason for choosing one over the other, or why you might be kicked from one into the other, from formal or informal into formal probate. Generally, formal probate is probate that takes place in front of a judge, or in some counties a referee, and the judge or referee oversees the probate process. There will be hearings on appointment of the personal representative, disputes, what else? Interpretation of a will, or distribution of the assets. Informal probate, a registrar oversees things. They actually make the decision about who it becomes a personal representative based on the submissions alone. And after that, probate is relatively self-administered. They're very similar in many respects. You kind of have to do the same thing, but how you get there is just a little bit different. The important thing that I do want to note is that whether you have a will or not doesn't matter. You can have formal probate with a will and without a will, and you can have informal probate with a will and without a will just fine. As you'll see in a bit, if you have a will, sometimes if it's poorly written, you're more likely to go into formal probate. But that doesn't mean that you can't have informal probate with will by any means. Now, do you need an attorney when doing probate, informal or formal? Well, formal, you most definitely need an attorney because you have hearings in front of a judge in court, and they're very formal, as the name implies. In informal probate, some people are able to get through it alone. However, just keep in mind that an attorney will certainly get through the process faster. There are a lot of statutory requirements and deadlines that have to be met, and there is personal liability for the personal representative if something is screwed up. So you might want to get an attorney if you're concerned about that. Which one is preferred? By practitioners, generally informal probate is going to be preferred. It's just, there's fewer filings, there's no hearings, it's just a little easier, and it's going to cost a little bit less. Now, if someone expects there to be, a problem, then oftentimes practitioners will just start by filing it formally and just ignore the informal application process. Regardless, whether you want to be informal or not, there are many reasons that you might be kicked from informal probate into formal probate. So it all comes down to the registrar. When you're applying to do probate informally, you put forth an application for informal probate, and then you just hope to see if the registrar is going to accept it. The registrar has a lot of discretion when doing this, but they basically have two statutory requirements. First, they need to decline an application that does not meet the statutory requirements of informal probate. So let's say you go at it alone and you screw it up, you might just be kicked into formal probate so that a judge can oversee things and make sure it's done right. Second, they are required to decline any application where basically it appears that a formal adjudication is required, and that is broad. There are actually many, many reasons why someone might be kicked from informal probate into formal probate. I've broken it down into three categories. Basically, if there's a problem with a person, if there's a problem with a will, and if the estate is insolvent. So a problem with a person can be a problem with a DIZ, which is someone who receives something because of a will, an heir who receives something as a matter of law, or a personal representative, which we actually spoke about in a previous video, so I recommend you watch that. But there are maybe 4 things, that general subcategories to the person problem, that will definitely kick things into formal probate. The first is going to be if there is a minor. Under the Uniform Transfers Minor Act, to which Minnesota subscribes, a minor who, for estate planning purposes, is under the age of 21 cannot receive an inheritance. Their assets must go into trust for them and held by a custodian until they turn 21. Also, a judge is going to want to oversee the probate just to make sure the interests of the minor are accounted for. The second thing where there's a problem with a person would be when there's a mysterious devisee or heir. And this could be where there's just uncertainty exists if a person is an heir or not. It could be there's a devisee with unknown whereabouts that you just can't track down. Or it could be an inaccurate description of someone in a will, such as you write down the wrong middle name and you get their birth date wrong. That identifies the person incorrectly. The third category under the person, or third subcategory under the person category, would be a dispute among the devisees or heirs, or at least a dispute that is foreseeable by the registrar. Now, this could be one of many things. It could be someone who is disinherited, or if there's an unequal distribution of assets in the will. A registrar might look at this and say, it's probably going to cause a problem. Someone's probably going to dispute it. Let's kick it to formal probate. It also could be if there's illegitimate children, if a child is given away to adoption, or if a devisee, this is my favorite or least favorite, if a devisee or heir murders the decedent, the person who died. If you murder someone under the Slayer statute, that's what it's called, the Slayer statute, you can't actually inherit from them, even if you're written into a will. The final subcategory to the person category is when there is a dispute with the personal representative. And this could be before the personal representative is appointed, or you could be informal, and at some point someone could try to remove the personal representative. You're going to be kicked right up to formal probate. The second category, gross category for things that will be kicked from informal to formal probate, is if there is a will problem. And this is basically like any other contract if there's a problem. If there is, specifically for wills and not necessarily for contracts, if there's a missing original, you're only supposed to probate original wills in probate court. Sometimes you can try to probate a copy, and if you probate a copy, then you have to deal with whether the original will was intentionally destroyed or not. You're going to need a judge to decide this. Second, if there's a failed distribution plan. Maybe the will tries to give away too much money. It gives $100,000 to Bob, $100,000 to Sue, but the estate only has $120,000 total. What if the will tries to give away too little, and there's a bunch of stuff that hasn't been given out yet? Then you'll need a judge to find out who gets those assets. And finally, is if there is nobody that certain assets can go to, there's no heirs, there is nobody in the line of succession, and it's just assets that are hanging out there, what's going to happen is those will escheat to the estate. That means the state of Minnesota will actually collect those assets, and it goes into a special fund. The second or third, issue with wills that you're going to run into is when there's an execution problem. If it wasn't dated, if it wasn't notarized, if the notary's commission is expired, if one of the witnesses is under the age of 21 when they witnessed it, all those things will kick the will up into formal probate. The fourth category or subcategory is when there's an ambiguous term. Now, this happens a lot with self-written wills. When people download documents or templates from online resources and they fill them out themselves, maybe they try to get creative, maybe they aren't trying to get creative and they just think they're writing things clearly, but they write an ambiguity into the will. You're going to need to bring in a judge to review the will and determine what the actual intent of the testator is. The final category for wills, or subcategory under the will problem, is when there's a handwritten will. Now, I'm not talking about a holographic will. And a holographic will is a will that you write yourself, and maybe you don't have witnessed, maybe you have to have it witnessed. It depends on the jurisdiction. In Minnesota, we don't allow holographic wills. You always have to have them executed properly. What I'm talking about here is when you have a will, and maybe after it was executed, the testator, the person who wrote the will, wrote notes in the margins and in between the lines to make changes to the will. This will have to go to a judge in a formal probate to determine what the actual intent of the testator is. Remember, if you amend a will, you still have to do all the formal execution things that you have to do when you're writing and executing a regular will. The final big category for things that will kick estates from informal probate to probate, it's a big one, is when the estate is insolvent. This is when there are not enough assets to cover all the debt of the individual. When this happens, you're going to automatically go into formal probate so the judge can try to equitably distribute everything and make sure it's done right. So that's the 20,000-foot view of informal versus formal probate. I hope you liked today's video. If you did like today's video, be sure to smash that like and subscribe button. It really helps support the channel. If you have questions, leave them in the comments below or just send me an email. I'm happy to take a look at them. If you like today's video and you want to see more on probate, you're in luck because we're doing a series on probate. I believe this is the 4th of, I don't know, maybe 10 or 12 videos that we're going to be doing. We release a new video every other Wednesday, so you can look forward to that. Until next time, this is Gregory Singleton with Signature Law.